Good morning. Welcome to the North Carolina Court of Appeals. I am Judge Allegra Collins. To my right is Judge Toby Hampson. To my left is Judge Carolyn Thompson. We welcome our marshal today, who is Chief Deputy Marshal at the Supreme Court of North Carolina, Ricky Parks, and our clerk is Mr. Eddie Sanders. We've got one case on the calendar today. It is case number 23675, State v. Andrews. Are you ready to proceed? You may approach.
Good morning. May it please the court. I'm Mary McCullers-Reese for the appellant Brian Andrews. I'd like to reserve 5 minutes for rebuttal. This case shows how an overbroad definition of restraint as an element of kidnapping can lead to an improper stacking of multiple punishments for the same acts. Because that's exactly what happened to Mr. Andrews here, he respectfully asks that this court reverse his conviction for kidnapping. So Mr. Andrews was convicted of 3 felonies: attempted armed robbery, attempted discharge of a firearm into an occupied vehicle in motion, and first-degree kidnapping. He got consecutive sentences at the top of the presumptive range for each of those, so a total active time of 29 and a half years minimum up to 38 and a half years maximum. The issue is whether the kidnapping conviction was actually additional punishment for acts that were an inherent feature of the other 2 convictions. So kidnapping at common law required an asportation, or carrying away, sometimes across state lines. Today, North Carolina's kidnapping statute, which has been here since 1975, requires the much harder to define and pinpoint restraint, which can mean confinement or restriction of motion. Can be by removal, but Mr. Andrews wasn't indicted in that way, so that's not the issue today. So restraint is a very broad term. Recognizing that, our Supreme Court held in State v. Fulcher, 1978, shortly after the statute came into being, that the legislature did not intend to make a restraint that is an inherent and inevitable feature of other charged crimes the basis for stacking, as the court said, like pancakes, punishments for kidnapping on top of punishments for other crimes. Based on Fulcher, the failure to present evidence of a separate inherent restraint goes not only to the double jeopardy, but also to the insufficiency of the evidence, as it does here. And there's good reason for the requirement. Any number of crimes that don't list restraint as an element, murder, assault, do, as a practical matter, involve some incidental restriction of motion.
Do you concede that there was some restraint, regardless of the other 2 crimes charged, that there was some restraint by the ban of the vehicle?
Arguably, there was restraint when he stopped the car on the highway, but even that was pretty clearly, even the state didn't argue that was anything other than inherent to the armed robbery.
What about when the van moves along to the side of the car and makes the car go a different direction that it was going to go?
I think that's
otherwise?
a much tougher case for restraint. He's not controlling him. He's still in control of his own car. He's driving in the direction he wants to drive. I think when you start making a chase into a restraint, you have a very different situation under the law.
Does restraint require control, complete control, or just an alteration of what somebody is doing?
As I think about, sure, there's a spectrum of what constitutes restraint. You're walking around with absolutely no one controlling anything, not so much as standing in your way, doing exactly what you want to. And then over here, I suppose there's first-degree kidnapping. But there's a lot of room in between there, and certainly this falls far closer to unrestrained. Under a different circumstances, would he be arrested or would he be fleeing to elude? Well, he's not restrained. This isn't what you think of when you think of restraint, and there is some element of that intended in the statute, I think. What do you classically think of as restrained? So when is a restraint separate and independent from that inherent in the other charges? Well, our courts have recognized certain factors, and we have to think about those. The one that comes up the most, it seems, in the case law is those situations the kidnapping statute was designed to prevent. That comes up over and over again, and you think, okay, are we talking about the Lindbergh baby kidnapping, a child snatched from their bedroom, carried away, and held for ransom? Not at all what we have here, but when you think of kidnapping, that's what was the statute designed to prevent? Certainly that. In that same vein, situations where victims are bound are more likely to have been have sufficient restraint. Situations where they're physically injured, where they're confined, and then the more nebulous situations where the victim is exposed to greater danger than that inherent in the underlying felony. So how do the facts here, as we started to discuss, fit into these factors? As to whether there was restraint, Mr. Rye wasn't confined, carried away, or held for ransom. He wasn't bound, wasn't injured. He wasn't even touched. He really wasn't ever even the same airspace as Mr. Andrews. Throughout, he was in control of his own car. He's driving, ultimately driving to meet up with law enforcement at a gas station. The facts here don't really have, as we're thinking about the Lindbergh baby kidnapping, that factor of demonstrating the type of abuse that the statute was designed to prevent. If that vague phrase can have a sense of what that it factor, that's not here. Possibly that's why the initial warrants didn't even mention kidnapping. As you look in the beginning of this record, kidnapping's not even on the warrants. And to any extent that there was some incidental impact on his movement, it was inherent in the other charges. To get a little more down in the weeds, I guess, to commit attempted armed robbery, a defendant must use or threaten to use a firearm. He'd also need, on these facts, to at least try to stop the moving car and get the occupant out of it.
But on these facts, to shoot at the car, you don't need restraint. You could shoot from just about as far away as possible and not be trying to make them stop, correct?
Sure, and he was also convicted of attempted firing into an occupied vehicle.
Correct.
So he got punished consecutively for that. He got consecutive punishments for each of those.
But restraint isn't inherent in that charge, correct?
I think if you are arguing that the restraint that you are, this is a unique restraint. We've had 50 years of case law in North Carolina, and we haven't had restraint by vehicle chase, where one person's in one car and the other's in the other come before this court. If you're going to argue that driving behind someone and making them change their course or causing them to go a different direction, arguably, is the restraint sufficient for kidnapping, then I think you have to consider the restraint inherent in shooting into an occupied vehicle in motion, which he was also convicted of, attempted shooting.
Is it significant that this was not indicted on a theory of asportation? Would that sort of change the analysis here?
It might have, Your Honor. And you're right. He wasn't indicted for removal, and certainly it could have, but we don't have that here. We have restraint. He's not restrained and he's not confined, classically how you would think of that. The state argues, and we sort of touched on it a minute ago, that we don't need to consider whether there was restraint in the attempted shooting into an occupied vehicle, because that's not a crime typically associated with restraint. And the courts haven't previously addressed it that way. Well, I agree. That's not a crime typically associated with restraint, as we were just discussing. And that implicates more the sufficiency of the evidence for the kidnapping than it does for the other crime. But the theory for this kidnapping was following in a vehicle, whatever restraint was inherent in that, and it wasn't the level of restraint you would expect for a kidnapping. It's inconsistent to contend both that the attempted discharge of a weapon at a moving vehicle imposed no inherent restraint, and that very type of restraint is nonetheless sufficient for a separate conviction for kidnapping. If we're going to broaden the definition of kidnapping, and it is a broadening, to include this unique circumstance where the kidnapped person has never been touched, bound, injured, dispossessed of the control of his car, I think we have to consider whether that same restraint is inherent to the other crimes for which he was convicted. State also says, well, even if you parse out any restraint inherent in the weapons charge, you still have a separate restraint because driving away at 90 miles an hour subjected Mr. Rye to a greater danger. Heightened danger is a factor courts consider in determining the separateness of the restraint from that inherent in other crimes. But heightened danger itself is not a substitute for restraint. In other words, driving away fast is dangerous, but it's not evidence of restraint. And a chase, by its nature, suggests that the chaser hasn't caught the one chased, hasn't restrained them. Unlike situations where someone orders captives into a separate room to commit a robbery, thus committing a kidnapping, Mr. Andrews didn't order or urge Mr. Rye to drive away, hence the chase. He didn't have control of him. He might have wanted to try to establish it, but he never did. If we now have, in addition to restraint and removal, kidnapping by pursuit, kidnapping by chase, it's a significant expansion of a basic element of the crime, a sort of concept creep of recognizing ever lesser degrees of control as sufficient for felony punishment.
Can we go back before
Yeah.
the chase, after he was stopped? There was some driving beforehand, and the van went alongside him and cut him off, forcing him to slam on the brakes. Is that, and I'm reading from the state's brief, from the facts there, is that a sufficient, I think, restraint?
Are we referring to when he actually stops the vehicle?
Exactly.
And
This is-
then he says, "Get out of the car."
And then he gets out of the car, Mr. Andrews, and walks around to the front. Is there any way that those are two separate scenarios? There's a kidnapping, there's a stop of the car, and then there is Mr. Andrews getting out, and that in and of itself is the attempted armed robbery.
Your Honor, I would agree that that is the attempted armed robbery.
Correct.
And then you are suggesting,
I'm asking you if the stop of the car before Mr. Andrews gets out, can that be considered a restraint?
I think he had to get, and in his attempt, if he's going to attempt to stop the car and cause take the car from the other person, which was ostensibly what he was attempting to do, that's part and parcel of it. I don't see that, certainly getting out of the car was, an incidental portion of trying to take that car, which is what he was convicted of and punished for with the attempted armed robbery.
Is there, I guess, from your standpoint, recognizing you're arguing the other side, but one of the pieces I'm struggling with here, and obviously I'll pose this question to the state too, but I'm curious your response. I mean, is there anything in the record that articulates exactly when the state contended at trial, or frankly on appeal, when this kidnapping occurred separate from the armed robbery and or the attempted discharging a weapon into a vehicle?
Your Honor, I read the state's argument to get their theory of the case several times. The state, even the state at trial did not contend. I think the state sort of said, all right, that's the attempted armed robbery. So even speaking with the jury, said, okay, we've got that. But then he resumes, and the state doesn't really even acknowledge that if you're considering a chase to be a restraint, which I contend that it isn't, but if you are, that's how he got convicted of kidnapping, that you would also need to consider whatever restraint was inherent in shooting into an occupied vehicle. So the state doesn't so much deal with that, which is, well, this chase subjected him to a greater danger, was the state's theory as I understand it. And I have to say again to that, greater danger is a factor you consider in making that determination, but it's not a restraint. It's not the same thing. I think it's the kind of case that makes you spin off hypotheticals, but under the state's theory, someone riding your bumper and high beaming you at night is also a kidnapper. And is that the kind of crime that statute was intended to combat?
Yeah, what is the mens rea for kidnapping? I mean, is it specific intent?
And you don't have that here. He was trying to stop the car, I'm not saying that was an admirable motive. I mean, he was convicted and punished for that, you know, and separately punished for each portion of that. He's trying to stop the car. As part of that, he then shoots somewhere near the car, in the vicinity of the car, enough to be convicted of that. What you have left over is a chase on the road, a highway chase. He's not touching him. He didn't hurt him. You know, when you talk about that it factor, that, you know, and I hate that, don't mean to be dismissive when I say that. When you talk about that kidnapping factor, that, what was the kidnapping statute? Because it says it over and over again in cases, and kept thinking, well, what does that mean? What is that factor that the statute was intended to combat? And someone driving away and ultimately meeting with the police, I don't really think that's the level of restraint that they're talking about.
You said hypothetical, and it instantly gave me one. And whether it's a good one or not, you can be the judge. But think about it more in sort of more classic armed robbery scenario. A store. Armed robber comes in, holds up the attendant at the cash register. There's whatever, the attendant sees an opportunity to escape, runs out the door with the suspect, the defendant, in chase. Is that, I mean, would that be a separate restraint or aspiratation perhaps enough to justify a kidnapping charge in addition to the armed robbery in your view?
It's very clearly the armed robbery. And then do you have something, a separate intent, a separate establishment of restraint or removal? Maybe in that case you have some kind of removal, but we don't have that prong here. As far as restraint, I mean, surely that means control, some level of control. And you know, there's a spectrum. It doesn't mean, you know, there's walking around doing exactly what you want, and then there's first-degree kidnapped. There's got to be some room in between and somewhere on that spectrum, and I would contend that this is not at the level of first-degree kidnap, not separate and apart from the underlying crimes for which he was also consecutively sentenced.
The state talks about defendant's high-speed pursuit of Mr. Rye was distinguishable. So in trying to categorize a high-speed pursuit as kidnapping, would you concede that it's attempted kidnapping, if this high-speed pursuit?
I think it's attempted is closer. I wouldn't concede that it is. I still think you have to establish a specific intent to restrain him, and I don't think that was the intent, to restrain him. It's separate and apart from the underlying attempted armed robbery conviction. So it's closer. It definitely is. I don't quite think it gets there. I would contend that it doesn't get there, Your Honor. And you can see how this very nuanced and aggressive pursuit of kidnapping conviction on top of the other two, how the stacking of punishment for inherent restraint that was inherent in the other two convictions played out for Mr. Andrews. The kidnapping was significantly more than what he received for the other two combined. The other two, which were the essence of what was going on here, attempted armed robbery and then a shooting into the vehicle. And then you have this, well, that's a restraint. So he gets a minimum of 199 months for the kidnapping, the first-degree kidnapping, and 155 for the other two combined. So you see how that doubles up. You might be saying to yourself, well, but 72 months of that kidnapping was the firearm enhancement. But the firearm enhancement couldn't attach to the other two convictions because they both expressly involved a firearm. So the kidnapping sort of gave him a double bite on the apple by calling this a restraint in addition to what it really was, which was an attempted armed robbery and a shooting into a vehicle, attempted shooting into a vehicle, and greatly ratcheted up the level of sentencing and punishment for it. It's a perfect example, really, of how a broad and vague construction of restraint gets around what the Supreme Court has held was the intent of the kidnapping statute, to punish only those restraints that are separate and independent acts from those inherent in other convictions. And it's exactly the type of double punishment that the Fulcher Court anticipated early on and cautioned against. Our courts have interpreted restraint by considering the specific facts of each case, and that's where this one gets down into it, is in the specific facts. The unique facts here, we would contend, do not show a separate restraint sufficient for kidnapping. Are there other questions from the court right now?
Yeah, I do have a question. So, so he was convicted of and sentenced for all three, correct? And he could be theoretically sentenced for any of them on their own, meaning if he was not convicted, example, for attempted armed robbery, then we wouldn't be here arguing about the kidnapping because those elements would have been met. Am I correct?
If the state had indicted him for just kidnapping, we wouldn't be here talking so much about, you know, I think there's certainly an argument as to if once you have that stop that was the armed robbery, I think that's harder. If you have that not as attempted armed robbery, but only as kidnapping, then I think you can say, well, there probably was a restraint, but it was inherent to the other one, we can't use it here.
Okay.
Did I answer your question? Okay.
Any other questions? Questions? No.
I'd like to reserve the rest of my time. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Hiram Hemingway. I'm an Assistant Attorney General with the North Carolina Department of Justice, and I represent the state in this matter. This Court should affirm the trial court's denial of the motion to dismiss for two primary reasons. First, the defendant's attempted robbery offense was complete when he ordered Mr. Rye out of his vehicle at gunpoint. All of the subsequent restraint that occurred constituted a separate and independent criminal transaction.
Just to clarify then, anything that happened before ordering him out of the car, you are not contending was restraint for kidnapping?
No, Your Honor, I think that would be inconsistent with the way the case was indicted and argued before the jury. I agree theoretically that initial stop could have constituted restraint facilitating what happened next, but it wasn't charged that way, and I think it would be improper for the court to affirm on that basis. The second reason the court should affirm is when you look at the attempted discharge offense that he was charged with. When you separate out, when you distinguish the single shot constituting that offense, evidence in the record that he fired at least two more shots and brandished a firearm as he pulled alongside Mr. Rye on Highway 64, forcing Mr. Rye to stop under that threat, constitute restraint within the meaning of the kidnapping statute. Beginning with the attempted robbery offense, when you have a defendant charged with kidnapping and a felony within the class of offenses that State v. Fulcher was concerned about, those where they cannot be committed without some kind of restraint, such as armed robbery, I can see that clearly falls within that class of offenses. If one offense is complete, meaning its elements have been satisfied prior to the onset of the second offense, that constitutes a separate and independent criminal transaction, as that term is described in Fulcher, in Boyce, in James, where one offense is complete, where there's no more restraint necessary, all the elements have been satisfied, and then there's subsequent restraint. That is what the court looks to.
But is there a difference here where, you have, it's an attempt, it's attempted armed robbery, it's sort of, an inchoate offense that wasn't completed by definition, right? So why isn't this entire transaction from beginning to end not an attempted armed robbery?
Your Honor, two reasons. First, I agree, inherent in the concept of intent is conduct that comes extremely close to completing the offense but fails, comes short. The attempt is thwarted in some fashion, I believe is the way it was instructed to the jury and the case law describes it. And it matters here that the defendant was charged with attempt rather than the completed offense. Because for the elements of attempt, once the defendant threatened Mr. Rye at gunpoint, once he was 7 feet away from him, standing outside, pointing a gun at him, screaming at him, ordering him out of the car, that was all of the restraint necessary to constitute the attempted armed robbery offense. And if you compare that to, for instance, State v. Boyce, in that case, individual is invading the home as the victim escapes. The defendant grabs and pulls the victim back in the home. Certainly, grabbing her and pulling her back in the home was necessary for the subsequent robbery to occur, but the court looked at that and said that brief period of restraint that facilitated what came next was a separate and independent transaction. All the restraint necessary to constitute the kidnapping was concluded when he pulled her back in, and then once he produced the gun and threatened her, that's when the armed robbery in that case occurred. And I know that was a completed offense.
And it's also the restraint occurred and was concluded prior
Correct.
to the robbery, which is a different from the theory of the case here.
Well, so there, in State v. James, the felonies occur in opposite order. In that case, the strangulation to the point of loss of consciousness occurs first. And there's really no break in the defendant's physical control over the victim in that case. But at the moment the victim lost consciousness, the court concluded that all of the restraint inherent and necessary to complete that offense had occurred. And therefore, the additional restraint that came subsequent to that was sufficient to constitute restraint for the kidnapping offense that followed.
But where is the second restraint here? There was a chase. At what point did they have actual control, did Mr. Andrews have actual control of the victim?
So, Your Honor, the defendant did not have control, and I would push back on the idea that control is necessary. Restraint is described by the Supreme Court as a restriction on freedom of movement. And so when we look...
He was still moving in his car. He never got out. He had free reign to just keep moving. In the theory of the defendant, it was kidnapping by chase. He never stopped enough to be restrained.
So, Your Honor, the state's argument, and I can tell from the reply brief and defense arguments and some of the court's questions that I could have been more explicit in my brief, and I apologize for that. But the state's theory of this case is that after Mr. Rye escaped, that's when the additional restraint began. And that restraint came in three different forms. First, the decision to pursue Mr. Rye communicated an implicit threat of harm. There's a reason why Mr. Rye was terrified, why he was fleeing, why he didn't go home, why he felt that he could not return home. That threat of harm and that restraint was amplified significantly when the defendant fired at least 3 shots out his window towards Mr. Rye. And that restraint reached its apex when the defendant pulled up alongside Mr. Rye, pointed the shotgun out the passenger side window as he side by side Mr. Rye. At that point, Mr. Rye had a decision based on what had occurred. He could keep driving and risk being shot or slam on the brakes. And he chose to stop. Before the trial court and even today, I believe the argument is the defendant was simply trying to stop the vehicle. His attempts to stop the vehicle through these various means constitute the restraint, and he succeeded when Mr. Rye threw on the brakes to escape the threat of being shot.
But his intent to stop the vehicle was to complete the robbery, not a kidnapping.
So, Your Honor, I don't believe that the defendant's the subjective intent is what controls whether this is a separate and independent transaction, as that term is defined and understood in the case law. Again, I return back to the cases I cited. What the court looked at, for instance, in State v. Fulcher itself, is a defendant breaks into the motel room, places bindings on the victims, and then proceeds to commit the sexual offense. And the court held that merely by binding the victims, the kidnapping had been complete, and it didn't matter if the subsequent offense had occurred. By the same token here, the defendant, once he ordered Mr. Rye out of the vehicle at gunpoint, that constituted sufficient restraint to complete the attempted robbery offense. Nothing further needed to happen. If he had chosen not to pursue, there would still be sufficient evidence for restraint for the jury to convict him of that offense. And I think it's significant that the defendant, after Mr. Rye escaped, he had to make a conscious decision to return to his vehicle and maneuver that vehicle around and begin to pursue. There was not just a break in terms of the restraint being complete that was necessary for that first offense, but there's a break in time and location where he could have cooled off And while that's not how these cases are generally analyzed, I think it's helpful to look at in this case that and this is how it was argued, I believe, in the motion to dismiss and to the jury, because the jury was instructed on the idea of a separate and independent transaction, and these arguments were made to the jury. So they considered that as they were deliberating, that everything that occurred after Mr. I escaped, that is a separate and distinct criminal transaction, even if we can infer, and I think it's, I think certainly we can infer that the defendant wanted to still take possession of the car, but the defendant was also charged with a terrorizing theory of the case. And I think it's just as strong of an inference that he was, at this point, frustrated, angry, and simply lashing out at Mr. I and angry that he had escaped and thwarted his attempt. And so I don't think that it's the court, when we are looking at this in the light most favorable to the state, can draw the conclusion that this is obviously, he was intending to this was all part of this one attempted armed robbery. I think we have to look at where the restraint necessary to constitute that offense is complete. I think that's how the courts have defined a separate and criminal transaction. And that's because all of that restraint necessary to commit the attempted armed robbery occurred before Mr. I escaped. That is why everything that occurred afterward is separate and distinct.
So if we go separate and distinct and we're talking about shooting into an occupied vehicle, it says at the bottom of your brief, when Mr. Rye was getting close to the intersection with Ridge Road, defendant fired several shots at him with a shotgun. Is it your contention that that crime was complete upon the shots being fired?
So so my contention with the discharge offense is that that is an offense that is not, where restraint is not inherent, and the Supreme Court analyzes those cases slightly different. The test is different. The court looks at whether the restraint that constitutes the kidnapping can be distinguished from the restraint that occurs during that offense. And if we break down what an attempted discharge into an occupied vehicle is, Section 1434.1 prohibits in relevant part attempting to discharge a firearm into an occupied vehicle. Discharge has a well-established meaning. It's the act of pulling the trigger and causing a bullet to be ejected from a firearm, such that each separate shot can constitute a separate offense. An individual fires 10 shots, they can be held responsible for 10 discharge offenses.
I think the argument on the other side is that this is sort of a factual determination that here it was inherent. You had to get close to the vehicle in order to be able to shoot into the vehicle. Is this an elements test or is this a facts test?
So, Your Honor, I think the elements, well, if I could complete my thought, I think it may answer Your Honor's question. And the reason I'm explaining this is when you separate out the single charge, or rather the single shot, that constitutes what he was charged with. He was charged with one count of attempted discharge. That requires proof that he attempted to or did discharge a single shot. There are at least two additional shots that are distinguishable from that conduct. So there's one shot that went to his attempted discharge offense. And based on Ms. Stewart's testimony, she was a witness inside the van. She testified the defendant fired, quote, more than twice. Viewed in the light most favorable to the state, that's at least 3 shots were fired. And 2 of those shots, therefore, can be distinguished from the shot that would be necessary to find him guilty of that attempted discharge offense. And this is a different analysis than if discharge were a crime where restraint was an inherent feature of the offense, because it's not under State v. Stroud, State v. Prevet, it's a slightly different analysis. It's a more favorable analysis to the state, being candid. And
so it's your contention then that 2 of those shots constituted part of this kidnapping?
Yes, Your Honor. So again, returning to the kind of the whole picture, the state's theory is that the restraint began with the pursuit. And again, that pursuit communicated a threat of harm. That threat of harm and the restraint that followed was amplified with these shots, specifically the 2 shots that aren't being allocated to that discharge offense. And then the restraint reaches its apex as he pulls up alongside Mr. I. From the testimony at trial, viewed in the light most favorable of the state, Mr. I could not outrun the van. His vehicle simply would not outrun the van.
Do we know which of the 3 shots defendant was convicted of? Do we know which of the 3 shots the jury would have relied on for the terrorizing theory?
Your Honor, we don't, and part of that reason is this issue was not raised to the trial court in any fashion. There was no discussion about all of the argument regarding the Fulcher issue centered on the attempted armed robbery offense. Defense counsel didn't bring any concerns, any unanimity concerns, any of that to the trial court's attention. And while there could have potentially been an issue there, potentially, I'll note that this is, the posture of this case is a motion to dismiss, which is different. It's not asking what the jury did, it's asking, could a reasonable jury find the defendant guilty based on the evidence and all reasonable inferences that can be drawn therefrom? And so, while perhaps if the issue had been raised, jury instructions could have been articulated to ensure that there were no issues with unanimity. I don't believe that's a concern for this court in this circumstance, based off the failure to object to the instructions, based on the failure to raise any concerns about that to the court during the trial.
So let me understand, you're saying that the kidnapping began when the defendant got back in his car and started to pursue, and then the 2 shots was what was necessary to restrain him?
The 2 shots, as well as the brandishing, when he pulls alongside Mr. Rye on Highway 64 and points his shotgun outside the passenger window as he's side by side with Mr. Rye's vehicle. And remember, Mr. Rye, based on the evidence, is unable to outrun this vehicle. So he, in that sense, in that moment, is forced to make a decision. Ostensibly, I think it would have been reasonable for Mr. Rye to believe he was about to get shot. And so he threw on the brakes. He stopped. And again, the argument for the trial court and before this court is that the defendant was simply trying to stop him. I agree he was trying to stop him. I think the evidence in the light most favorable state shows he was trying to stop him. And that effort to stop him is evidence, strong evidence, and the fact that the victim actually stopped is strong evidence that he was restrained. He was restrained by the threat of a gun essentially staring down the barrel of that gun as he was driving, trying to get away. He had no other choice. Well, I won't say he had no other choice, but it was a reasonable choice for him to concede that he was caught, slam on the brakes, and then try another evasive maneuver. And the case law is clear that we don't use a stopwatch, we don't use a measuring tape to measure the quantity of restraint. And I would submit that the restraint here, facing the gun and slamming on the brakes, is greater or at least equal to the restraint in Boyce, where a defendant physically pulls somebody back into a home over a short distance.
Can we chat a little bit about the indictment? I assume that there's no superseding indictment. There's only one indictment for first-degree kidnapping?
I believe there's just one indictment,
Okay,
Your Honor.
so it says the defendant committed the felony alleged in this bill of indictment by using, displaying, or threatening the use or display of a firearm, and the defendant did actually possess the firearm about the defendant's person. There's nothing in here about driving, about chasing, about causing somebody to slam on the brakes. There's nothing in here about a car. Is that correct?
I believe so, Your Honor. I'd have to take a look at it,
Okay.
if the court might give me one more.
Yeah, it's on the record, page 7. So I just, we've talked a lot about confining by chase or confining by pulling up beside the car, but that's in the indictment. Are we constrained by this indictment to only consider pointing the gun?
Your Honor, again, unlawfully confined and restrained without his consent. So I don't believe that the indictment has to set out all of the evidentiary facts that support the act of restraint.
But if it does lay out some, aren't we confined to those?
Well, and Your Honor, I believe so. And here he was restrained by the threat of a firearm, the threatened use of a firearm. Again, the only reason, from the state's view, the reason that initial portion of the chase was threatening is because of what had occurred with the firearm and the fact that Mr. I knew that he possessed a firearm and had been threatened with it. Take the firearm out of the case, and I don't believe there's any restraint inherent in that initial portion. And then the firing of the shots is additional use and threats of that firearm, and the brandishing is additional use and a threat accomplished via that firearm. To the extent that the court has concerns about the indictment, I believe that the state's theory at trial and on appeal is consistent with the indictment, that it was his use and possession of the firearm during that chase that created the threat of harm that was amplifying throughout as the chase proceeded, and that constituted the restraint that again continued to increase as the chase continued on.
I'm going to ask you the question that you don't want me to ask you, which is, should we, if we do not agree with the state's position in this case, you know, what's the state's position on the remedy here? Is it simply to reverse the first-degree kidnapping conviction, or is there room for remand for a new trial on, you know, on a lesser included or the attempt or whatever?
Well, Your Honor, I think that if the court finds that the motion to dismiss should have been granted, the motion to dismiss the kidnapping offense should have been granted, then I believe this.
As to first degree.
Well, let me think. The second-degree kidnapping, the distinguishing feature would be the release to a safe, whether it's released to a safe place. I don't believe that's being contended here. And I guess the question is whether that would, to an attempted kidnap, is that Your Honor's question, whether there would be reason to remand?
Yeah, I was just, I don't know, sort of thinking on the fly here, whether that's, I can never remember whether attempt is actually
Your Honor,
considered a lesser included or not.
I think certainly a completed offense can satisfy an attempt, and so there may be a lesser greater relationship there. But my understanding generally of the case law is that if a motion to dismiss should have been granted, then it should have been granted, and the court would vacate that judgment and potentially remand for resentencing, although I don't know that that would make sense in this case because the court had issued consecutive sentences and vacating would accomplish the effect of vacating that sentence. And so I don't believe that the court would need to remand.
Okay, thank you.
And so I just want to address a couple of the questions the court asked during counsel's argument. And I want to be clear that restraint does not require complete control over an individual. I don't think that bears out in the case law. And I appreciated, Your Honor, Judge Hampson, your question, your hypo regarding a robbery that begins and then somebody flees on foot and then is chased. I think that's actually very illustrative of the principles that I'm trying to articulate. Remove the cars from the situation and consider an individual is walking, somebody jumps out and says, "Don't move or I'll kill you, I have a gun." And that person freezes briefly and says, you know, "Give me all your money." And the person waits for a second or third and then decides, "I'm not waiting, I'm running," and they bolt off. And they run off into the woods. And the person, the assailant begins to chase them, fires shots, threats, is doing all these acts. And the person, because of that chase, because of the shots, because of the threats, is certainly being confined in where they're going. And when it comes to restrained, their freedom of movement is being actively suppressed by that individual's actions. That, I think people would have it wouldn't be as hard to conceptualize that that would be restraint. That individual being forced to hide out, forced to evade, that sort of situation would be restrained. Their freedom of movement would be restricted. Here, and I don't think the fact that Mr. Rye is in a vehicle changes that. Certainly he can go faster, but he's not faster than the defendant.
So does that make every attempt to shoot somebody a kidnapping?
I don't believe so, Your Honor. I think the Supreme Court has really distinguished these cases, and it talks about how these cases turn on the pertinent facts and the sequence of events. And so it really matters. Every case turns on those facts. And when you have identical facts, but they occur in a slightly different order, that makes a huge difference and can be determinative of what happens. And so I don't think we can paint with a broad brush and say anytime there's a chase with a gun, a failed robbery, that it would necessarily become a kidnapping as well. I think it really matters on what occurs in each case. And here the state's argument is that, firing a gun at somebody and essentially threatening to shoot them for the purpose of stopping them, getting them to stop, or for the purpose of terrorizing, that sort of conduct falls into the heartland of conduct that the kidnapping statute is designed to protect someone from. The state's not asking this court to broaden the definition of restraint, not asking the court to turn any high-speed chase into a kidnapping case. It's really focused on the facts of this case and the defendant's use of a gun and how he threatened Mr. Rye with that, how he used that gun after Mr. Rye was able to escape the initial stop when he was being held at gunpoint. And it's the defendant's threats and restraint that arose from those threats that provided a basis for the court to affirm, that provided a basis for the trial court to deny the motion, and that provide this court a strong basis to affirm the denial of that motion to dismiss. And if there are no further questions, I'll submit.
You good, Judge?
No,
Okay, thank you.
Thank you.
So briefly, I'm trying to think of an example where it doesn't transform a shooting where you're walking behind someone shooting at them into a kidnapping, regardless of what the intent was. If that passes muster, if this passes muster as a kidnapping, then I am trying to think of what situation walking into the woods you aren't, after someone that you aren't also going to have an add-on, big tack on. Class C, much larger than what the underlying felony was, where that wouldn't be the case. North Carolina has had a kidnapping statute and cars on highways for a long time, about 50 years, but we haven't had a body of law of kidnap by car chase. And I think there's a reason for that. There's a spectrum of infringement of freedom of motion between zero, complete freedom, and victim of first-degree kidnapping. So we have to recognize not just the classification, but the degree in considering what constitutes restraint, or else we are sort of doing the, tape measure and et cetera, in a way different from what was anticipated by that court. But again, you are sort of getting, push this button, pull this knob, and you get to, and it really doesn't lend itself to that. Having someone drive behind you, even aggressively, it's aggressive driving, okay, but without ever controlling you, without ever establishing restraint on you in a way that, he can't control what he's doing. In fact, the whole driving away was outside of what Mr. Andrews was in control of. He didn't tell Mr. Rye to drive away. He wasn't in control of the direction. He didn't suggest or urge that in fact, that was exactly the opposite. And so I don't think in all these hypotheticals we have, the kidnapped victim does exactly what the kidnapper doesn't want them to do, and then is deemed restrained for purposes of kidnapping.
Let me hear your response to counsel's statement that once it stopped, the first stop, everything after that could be considered fair game for the kidnapping theory.
I don't see how, well, first stop, you've got attempted armed robbery. I think he still hasn't accomplished an armed robbery, so I'd say the intent there is still an attempt to take that car, pretty clearly. Then you have this shooting, which he's also convicted of. So in order, certain aspects of that, I would agree that's not typically a restraint crime. But here, since this is the restraint that's been alleged and convicted on, it is. So you have, after you have that initial incident, that stop, he's still attempting armed robbery. And at one point, the DA even says in his closing argument, maybe this is just another attempt to have an armed robbery, and then moves on with his kidnapping argument. Well, I mean, that's not the way he was indicted. That's not what it was indicted as, and it probably wouldn't have been successful because you don't have the overt act. But the DA sort of acknowledged that problem, that there's an ongoing intent to take this car back for that purpose. Did that answer your question?
Yes, ma'am.
I'm not sure it did. Okay.
And the jury was instructed that the kidnapping was for the purpose of facilitating, or they had to find that the kidnapping was for the purpose of facilitating not just a felony, but the armed robbery.
But the armed robbery, and also. Our system puts a lot of faith in juries, and it should, it always has, but juries need judges to winnow out issues that shouldn't be before them so that they can decide cases in keeping with the intent of the law. Here, it was error for the trial court to submit kidnapping to the jury because the evidence of restraint by chase, which is what the counsel of the prosecutor was relying on, was a radical departure from what's been required previously for kidnapping. Are there other questions from the court? I want to talk about what you guys want me to talk about. And if there aren't,
I don't have anything else.
We don't. You may close.
If there aren't, if there are no questions, I respectfully request that this court reverse Mr. Andrews' conviction for kidnapping. Thank you.
Thank you. Thank you both for your excellent arguments. Mr. Clerk, you may close court.